Okay. Welcome everybody to the 5th annual Rochester Law Symposium. Special milestone, 5 years. Before we get into today's program, I have to read off the housekeeping rules. So welcome to the Monroe County Bar Rubin Center for Education. Today is June 6th, 2018. The title of today's program is Get Real, which is an acronym. We'll see soon what it stands for. Avoiding Harassment Claims, a Legal and Judaic Examination. This is a collaboration and hosting by Chabad of Pittsford and Rochester and the Monroe County Bar Center for Education. Just a few more housekeeping rules. CLE credit to comply with accreditation regulations. Please fill out your evaluation sheet at the end of the program. Drop it in the tray located at the exit door. In exchange, you may pick up your certificate of attendance, which will be arranged in alphabetical order on that table by the exit door. Please note all attorneys must attend programs in their entirety to receive credit. Just a nod to the past couple of years. We had Frank Hillerberg as the chair of this event, and he also mentioned that the date is June 6, 2018, also known as the 23rd of Sivan 5778, for those that remember the inside joke. Okay. I want to first of all give a couple thank yous to Mary Beth Feint and Diane Nash and all the staff for their hard work and really making this a pleasure to bring year in, year out. A very big thank you to our underwriters for making today possible. The gold level underwriters is Wood Oviatt Gilman and Bond Shenick King. Silver level underwriters M&T Bank. And bronze level law office of Stephen Grudensky. Before we get into the program, I just want to you might notice you have a single individual paper that they gave out at the front, and it gives you a little glossary of some of the Judaic ethical main works. You can read it for yourself. But rabbis and lawyers, rabbinic scholars and lawyers, really have a very similar job when you strip away the different application, but they're a very similar concept, which is they have to take law and make it accessible and translate it into day-to-day practice for the masses, for their clients and congregants. The word actually, the collective word for Jewish teaching is called Torah. Etymologically, it shares the root of hora'ah, which means a practical instruction. So in Judaism, the abstract, the theoretical, is always judged and utilized for the practical application as well. Being that this is our 5th year of the Rochester Jewish Law Symposium, that's a very special milestone. And don't just take my word for it. I brought you down in the paper, in the bottom of the little one-page handout. The core teachings of the Talmud is called the Mishnah. Sort of I don't know what that would be compared to in a legal, modern legal tone. That's the core teaching, and the Gemara is the elucidation. So there's a famous volume of Mishnah, of teachings, of core teachings, that are called the Ethics of the Fathers, which are proverbs and ethical behavior tidbits from the rabbis. Not so much legal, but more ethical. And in the Mishnah of Ethics of the Fathers, chapter 5, Mishnah 22, it lists a bunch of milestones in life. I'm not going to go through all of them, but the first 3 are relevant to the 5th anniversary of our symposium. It says in educational readiness of a student, 5 years old is the age of study of the Chumash, the scriptures, 10 of the study of the Mishnah, and 15 for the study of Talmud. Every 5 years is an advancement in learning. So if you can take this, in our case, 5 years ago, we started this program. Every year it's gotten better and better and more tweaked and honed. Incidentally or providentially, Rabbi Yaffe was there the first year, and now he's back for the fifth year. Coincidence? I think not. And the main thing is we should always look at a milestone as an opportunity to learn wisdom deeper and continue with it. It should apply to our lives and our practice. On the back of this page, you can keep it if you'd like to, or just, for Chabad's own interest for future symposiums, there's a bunch of topics we'd like to consider doing in the future. If you like and you'd like to put in that little box at the end of the table, at the end, it will help us know the best topics for future symposiums. Okay, so today's topic is obviously, out of all the topics we've done, is probably the most current. We have two very esteemed presenters on the topic of harassment in the workplace and how to set up appropriate boundaries. I'm going to briefly introduce them. Their full titles and accomplishments are in the handout. Sharon Stiller is a partner and director of the employment law practice at Abrams Fensterman, and as many of you know, a well-known expert on employment law and the subject of today. Rabbi Shlomo Yaffe is the Dean of the Institute of American and Jewish Law, amongst other things, and he's served on many panels, giving the Judaic ethic side to many CLEs, probably numbering in the hundreds, if not thousands at this point. It's a pleasure. We've had both of them in the past to great success. It's really a pleasure to have both of them back here to present. So we're going to start off with Mrs. Sharon Stiller presenting on the topic. One more housekeeping thing. The video viewing codes for the CLE are 1983 and 2479.
This comes way down. Thank you, Rabbi. Before I begin with anything, I want to just say how cool I think this program is. To really be exploring topics both from a civil law side and from the Jewish side, and to come up with these ideas, to do it each year takes a tremendous amount of work. Also, Rabbi Yitzi has agreed to be moderator. First time he's ever moderated a program this year, so I think he deserves some applause. So if you could just thank him for everything that he's done. See if I can figure out how to do this. Apparently not. This is me. So this is a topic that I feel pretty passionate about. I'm going to be talking about some of the legal aspects of sexual harassment or harassment in general, but more so about why it continues and some of the issues and what we can do to make it better. This first page of If Only They Had Received This Training, this is just the start. It probably could be 10 pages long of people who have lost their careers, lost their respect, lost their businesses, with Harvey Weinstein now been indicted. We have people like being accused in this Me Too era, like Morgan Freeman, Tom Brokaw, and it's a different time than it was before, and there are some things that I think have created it. But it's not a good situation. It's not a good situation for anybody. And one of the things that we'll be talking about are the costs of harassment and what it's cost to society, which then leads us to what we should try to do about it. One of the best statements that I've heard about harassment, or just understanding what it does, was from the comedian Louis C.K. And I'm not going to read the whole statement, but basically what he said is that he never realized the power he had, and he exercised it irresponsibly. So he said, the power I had over these women is that they admired me, and I wielded that power irresponsibly. And that's really what we're going to be talking about. I think if you could talk to the people that I said in the beginning, if only they had taken this training or attended this session, really, if only they had heard a lot of what Rabbi Yaffe is going to be saying, then maybe it would be a different society, a different situation. When I do trainings in sexual harassment, I have pages and pages of myths and facts, but I just want to go over a couple of these. First is the myth that highly paid employees or professionals do not engage in sexual harassment. We saw the list on the first page, and of course that's a myth. The other myth that I think it's fair to point out is the myth that if people don't complain, sexual harassment or harassment based on a protected category doesn't exist. That's just not the case. We often hear people say, well, he's harassing me, that's illegal. Harassment itself is not illegal, but harassment based on a protected category is illegal. And there are a variety of protected categories in New York State as well as under federal law, and these continue to be to change. They're somewhat volatile. They're somewhat, as we become more sophisticated, the concepts become more sophisticated. So, for example, there's a recent case in the Second Circuit, an en banc decision from the Second Circuit that found that Title VII covers sexual orientation. There's a petition for a writ of certiorari to see if that's going to go up to the United States Supreme Court. There's a Sixth Circuit recent decision that says that Title VII covers transsexualism and transitioning. So there are a lot of protected categories because people in those categories need the protection of the laws, and it's an ever-changing arena. We've had Title VII since the 1960s, since 1964 on the federal level. We've had protections on the state level, I think, since 1938. So the question is, do harassment claims still exist? And the answer is a resounding yes. In fact, the harassment claims based on all of the protected categories are about 1/3 of all of the claims. So that leads to the next question of why. If we've had policies against harassment for 30 or 40 years, since 1964 when Title VII was enacted, if we've had trainings, why is it that this abundance of claims still exists? In 2016, the EEOC did a study. Actually, it was the two co-chairs of the EEOC who headed this study. And the study was about harassment in the workplace. The conclusion that they reached was that too many people in too many workplaces find themselves in unacceptably harassing situations when they are simply trying to do their jobs. And, you know, if you go back and you look at the silence breakers, the people who brought some of the issues to our attention, that's exactly it. What they've said is all they wanted to do was to do their jobs, but they were subjected to harassment as part of it. We talk about costs. There are costs to every party involved in the equation. So the costs to victims include things like emotional trauma, missed career opportunities, attorneys' fees. But I've heard a number of times people say, well, if you don't like it, why don't you just quit your job? And what the EEOC study concluded was that there are many people who don't have a choice. If they quit their job, they can't support their families. They're living paycheck to paycheck. Or if they quit their job and they go to another job, they're going to have to start their career ladder at the bottom, last rung. So it's not necessarily a viable option. And it's not fair to say that your choice is to start at the bottom rung or to be subjected to harassment. What about the cost to business and society? And I could go on and on with this stuff, so this is the abbreviated version of it. But look at Weinstein. There were at least 8 settlements with women since the 1990s, and now the company is bankrupt. He's been indicted. O'Reilly, Fox News. I actually find this a little bit amusing. I probably should not say that on tape. But O'Reilly, Fox News paid $13 million to 5 women in relation to that claim. And then there's municipal claims. So there's Blake Farenthold, GOP Texas representative, who settled his sexual harassment cases by using public funds. And he recently was forced to resign as a congressman. And that's one of the reasons for some of the new laws that I'm going to be talking to you about briefly, because there's for years, the way to deal with the situation was to settle them and to settle the cases for large sums. What about bullying? What about bullying that doesn't rise to the level of harassment? Is there a cost in the workplace? And I add that in. There was a proposal in the legislature a number of years ago to create a prohibition against bullying. And I, for one, think it would be very difficult to enforce. It would be very difficult to define. So I was not disappointed when it wasn't enacted. But it's important to point out that that doesn't mean that it's a good thing to have in the workplace, because there's a cost to bullying. And as you see, some of the studies show that the cost of bullying can cost a single business up to $100,000 per year for things like people not wanting to come into work, sick leave, reduction in productivity, things of the sort. And the second statistic that I have here is also found to be startling, and that was a study of 9,000 federal employees, and they reported that 57% had been bullied over a 2-year period, and the study estimated that the cost to the organizations was $180 million. I'm sure that there's a cost to bullying as well as a cost to discrimination. Now, I'm going to return to that in a minute when we talk about what we do about it. I just want to give a brief synopsis. We have a pretty sophisticated audience, but I just want to do a brief synopsis of what is sexual harassment and some particular issues with respect to it. So, as I said before, sexual harassment is a concept that was born of Title VII. It's interesting also how Title VII covered gender, if you folks don't know, and it's mentioned in this recent Second Circuit case. Gender was thrown in at the last minute by the Southern Congressmen at the time. There's very little legislative history over what they meant by gender, and some think, and you can read this in the opinion that I was mentioning, some think that what they meant by gender was nothing. They were just looking for a way to avoid passing Title VII and having an anti-discrimination law that covered race, national origin, and religion. We've had discussions, and Rabbi Yaffe will be following up on this substantially, but any harassment and sexual harassment in addition really is not sexual. It is a method of gaining power over somebody, making them feel uncomfortable. So the definition of sexual harassment is unwelcome sexual conduct that becomes a term or condition of employment. There's generally 2 kinds of sexual harassment: quid pro quo harassment, which is where somebody asks for a sexual favor or says that if you don't give a sexual favor, you'll receive some sort of, you won't be hired, you'll have problems in employment. And then there's hostile environment sexual harassment, where a bunch of different types of conduct all accumulate to create an intimidating and offensive environment. And that may be conduct that's done by 7 different people, but each person plays a part in it. And then, of course, there's the concept of retaliation. So oftentimes, retaliation is an issue. The issue is, how do you treat somebody who's complained of discrimination? And it's a very, very difficult issue, as are most of these issues. But it's a very difficult issue because nobody really knows how to deal with somebody who has complained about discrimination, and how to, the answer is, of course, you treat them equally as though they had not complained, but realistically, psychologically, how do you do that? In order to meet the criterion for sexual harassment, the sexual harassment has to be pervasive and unwelcome. And I'd love to tell you about some of my favorite cases, like Meritor Savings Bank, which is one of the first cases that recognized sexual harassment. In that case, there was a bank employee who had sexual relations with her boss on a number of occasions, and basically stopped coming to work. And it was one of the first cases in the United States Supreme Court that recognized the concept of sexual harassment. But where do you draw the line? What is too much? So what the courts say is that, and what the EEOC says, and incidentally, I've given you some materials from the EEOC, so I've given you some interpretive guidelines. What they say is, if it's an isolated or sporadic comment or picture, cartoon, calendar, whatever it is, then that's probably not sufficient to constitute sexual harassment. But if it's constantly offensive, then it is. The cases have also said that a single unwelcome touching of the victim's private body parts is sufficient to constitute sexual harassment. And I think that the concepts make sense, but it's often difficult to put it into context. The other question that the courts have addressed is who can be a harasser and who can be harassed. There are some very, very interesting cases, like the question about when the coach sends the players out on the field and pats them. Is that sexually harassing? One of the questions that came up in some of the same-sex cases, but the courts have ruled that there can be same-sex sexual harassment. What about consensual relationships? Consensual relationships are some of the more difficult issues that I see in advising clients in the workplace, because the question is, how do you know if it's consensual? If sexual harassment is based upon a power differential, what does consensual mean? Is it consensual when a student has a graduate student has a sexual relationship with the person who's going to be determining whether they get their graduate degree? So there are all kinds of issues with it, stemming from the power differential. So, to back up, we've learned that there is a compelling case to stop harassment. The cost to business is astronomical. In 2015, the EEOC recovered $164.5 million from businesses for workers alleging harassment. The cost to victims we've heard about in the Me Too movement. And then we have the cost to the alleged harasser, the loss of reputation, the loss of business, the loss of being able to perform their usual occupation. I don't think it's illustrated anywhere more vividly than with Bill Cosby, who fell from being a revered figure to someone who really can't show his face in many places. So why does it continue to occur? Well, first of all, there are natural barriers to prevention of sexual harassment. The statistics show that 3 out of 4 cases often go unreported. The second thing that the EEOC found in its study was that simply focusing on liability training, like what I just did, telling you what sexual harassment is, but not understanding it more, does not do anything in terms of lowering the statistics, lowering the claims. So what the EEOC has said is that we've got to change our mindset with respect to preventing harassment in the workplace. They've said that leadership is critical. So the tone and the tenor of how you behave respectfully in the workplace has to be established from the top. The second thing is that there has to be accountability. So people need to know that they have a safe and respectful workplace, and that if anybody deviates from that, then something is going to be done so that they can ultimately have a safe and respectful workplace. The EEOC pointed out that training is critical, in fact, and responsibility is critical. In fact, they actually even made what I think is a controversial statement that instead of rewarding managers when there are no claims of sexual harassment in their workplace, they should be rewarding managers when there are claims, because if there are claims, it means that the system of accountability is working correctly. And then the EEOC has also advocated bystander intervention training. So years ago here in Rochester, the Urban League had a pledge that was as follows. Not only will I not engage in discrimination, but I will not allow any discrimination to occur in my presence, which I think is a very, very powerful statement of respect in the workplace. And what the EEOC has said is that we need to train other people to understand that they have a responsibility, maybe not a legal responsibility, but a moral responsibility to step in and to do something about a harassing workplace. They called it an It's on Us campaign, which I think is a very good phrase for it, meaning that we're all part of the workplace. We're all going to take responsibility for making sure that we have a respectful workplace. So I say it's going from a Me Too workplace to an It's on Us workplace. And I actually have my own thoughts about the Me Too workplace too, because I think for many years the victims were silenced, but I think now what's happening, which is equally difficult, is that when there's an accusation, the person who's accused doesn't necessarily have a voice either because of the power of an accusation nowadays. How much better would it be if we went to an It's on Us workplace where we all take responsibility for having a respectful workplace? New York State has taken the position, and actually New York City has done the same thing. I've included some of the materials in the materials that I've given to you. But New York State has enacted some new laws, some pretty powerful new laws, as part of the budget bill that occurred in March of 2018. Some of the provisions are effective in June of 2018. The most important ones, as far as I'm concerned, take effect in September of 2018. And what New York State has said is that all employers, regardless of the size of the employer, so all of your law firms and all of your clients are going to have anti-sexual harassment policies and conduct anti-sexual harassment training of each and every employee annually. So I'm gearing up to provide that service for companies, but it's not too soon to begin to prepare for it. The change in sentiment is astounding. I've included in your materials a case that's a recent case involving the New York Transit system and the New York Transit Authority. And that was an arbitration case. We all know the general adage that an arbitrator's decision is not going to be overturned because it's wrong. Well, this was a sexual harassment case, and the appellate court overturned the decision based on the fact that the arbitrator engaged in victim blaming and did not give the have the kind of understanding that the appellate court felt that the arbitrator should have had with respect to the claim of sexual harassment. So to me, it really reflects a new world with respect to that. We've talked about the must-haves, policy, training, things of the sort. I want to end with a case, and we'll have more time later to discuss all of these concepts, but I want to end with a case and a policy. So one of my favorite cases, and I have these little pet cases. So one of them is a case that is an old case, Robinson versus Jacksonville Shipyards. And it was a case that involved two female welders who went to work in a shipyard. And in the shipyard, they had up all of these calendars that had nude women on them. And then they had the plumbing pieces and things of the sort covering some of the private parts. And these two women complained and said that they were very uncomfortable having these nude calendars up. And the powers that be said, aha, we're going to listen to your complaints. We know what we're going to do. We're going to take all of these nude calendars and we're going to put them in the work trailer. So they're just in a single location. You don't have to look at them all the time. Well, the work trailer was the trailer that assigned the work. It certainly made the two women, feel like they were not listened to. And so they did what people who feel like they're not listened to do, which is they sued. And the judge basically said, okay, Jacksonville Shipyards, you are so stupid that what I'm going to do is impose a policy on you guys. And I'm going to define for anybody what sexual harassment is so that even you will know. So they started with the most significant things, and they said sexual harassment, prohibited sexual harassment, includes physical assaults of a sexual nature, intentional conduct of a sexual nature, such as brushing against somebody, grabbing, and there's all kinds of illustrations I can give to you about this. Unwanted sexual advances or propositions, that's basically what we were talking about with respect to quid pro quo sexual harassment. Subjecting somebody to threats of an impact on their work conditions as a result of not giving in to unwelcome sexual advances. That's really a lot of what you've heard in the Me Too situations. Preferential treatment, and there's some issues about whether sexual favoritism does or does not constitute sexual harassment. I've actually given you a policy guidance with respect to that too. And then in answer to putting these things in the work trailer, displaying signs or materials purporting to segregate an area by sex, or reading or publicizing, I'm going to go back one. I'm not well. I'm not going to go back to that one well, so I would have to go back to the slide. Okay, having reading material in the workplace that is sexually revealing or sexually offensive. And a lot of this also, I think, depends on the kind of workplace it is. If you're a book publishing company, and there's certain kinds of books that you publish, you might have something that's offensive in the workplace, but it's not intended in that manner. Then they answered the question about, or the argument that the Jacksonville Shipyards made that, well, this is just benefiting our suppliers when we have these calendars that they gave us. And they said that displaying pictures or promotional material in a sexually or demeaning way is prohibited, and that a picture is going to be presumed to be sexually suggestive if it depicts somebody who's not fully clothed, and it's for the obvious purpose of drawing attention to the private portions of the person's body, which was Jacksonville shipyards, of course. We know why you had those calendars. Intentionally pressuring, falsely denying, lying, covering up, retaliation that we talked about before. And then the very last thing that the judge said, and really the main reason why I provide this for you, I think it's one of the best, most inclusive descriptions of what constitutes sexual harassment, but I really like the last statement. So what the judge said is, this isn't all inclusive, but what you need to know is that sexual harassment is unlawful and it hurts other employees, that each incident contributes to a general atmosphere where everybody shares the victim's, who shares the victim's sex suffers the consequences, and therefore people who engage in this conduct need to bear responsibility for their actions. So this is just a very brief discussion. We'll have an opportunity to talk about it more, and now we'll learn about the fascinating, I think, Jewish aspects of this topic. Rabbi?
Thank you, Sharon. That was an enormous amount of information presented in a highly accessible way in a short period of time. Thank you so much. So first of all, I want to reiterate perhaps things that have been said in previous years. Okay. I want to reiterate things that have been said in previous years regarding this issue. And what I mean to say, why are we co-joining Talmudic law to a study of American federal and New York state law? So first of all, there's always the fact that any legal system can learn a great deal from issues that have been brought up in other legal systems, and there are always new perspectives that are valuable. But it's also true in this case that precisely some of the differences between Judaic and American law are useful. When I say they're useful is because they give us different perspectives on the issue, precisely because in certain areas Judaic law approaches issues from a different angle, a different set of lenses than does Western law. Some of the issues that are vexing, that are problematic, as Sharon pointed out, there's a lot of ambiguity in establishing what exactly is going on and how exactly you define various types of harassment. Because Judaic law, as we shall see, takes an approach from a different, shall we say, center of reference, a different center point, it's helpful in many ways. And it really goes back to the question of education, to the understanding that sexual and other harassment cannot be dealt with except by fundamentally changing the assumptions and the paradigms and the set of, shall we say, permitted to oneself behaviors that exist in the workplace and elsewhere. So, a few quick caveats that what we're going to discuss, there is no particular set, there are a few issues, but there is very little Judaic law about the workplace in particular, other than the fact that the sense that people who are subordinate are likely to be harassed. As a matter of fact, though there are many biblical examples dealing with the behavior and the avoidance of the type of behavior we're going to speak about, the very first case, the very first example in any legal text that I know of of anti-harassment education, we just read, those of us who read the book of Ruth, on Shavuot, where Ruth is this convert, this very poor person who's gleaning, as Jewish law allows and demands that any grain that falls from the sickles of the reapers is to be left for the poor. And there's a bunch of young men working in the field. So Boaz, the owner of the field, the proprietor of the business, tells his young men, you see there's a young lady gleaning after you, don't bother her, don't harass her, or else you're in trouble. And the point is, there's an awareness of the problem, there's an effective, took a sentence, but an effective education system, but an awareness of the issue in spite of all the social hierarchies that may have existed at the time. I mean, this line in the book of Ruth is really important because it encapsulates what has been the attitude for 3,500 years. Now, you can say that Judaic society was very traditional. You can claim, though I'm not so sure, I would object to the claim that it's highly patriarchal, etc., etc. But we can leave those arguments for another time. The fact is that Judaic law and ethics has been profoundly aware of this type of issue, that of power differential and harassment based on gender and so on, and Judaic law has a very unique angle to this. Let me also say that there is a very key point over here, which is that I'm going to be mostly talking about men. You know, years ago, at the very beginning of the second wave of feminism in the mid to late 60s, UC Davis has a journal of criminology. UC Davis is famous for being a very progressive kind of campus. So they had a journal of criminology. This is the mid 70s. So they wrote that we are going to use, we're going to interchange the pronoun, the gender pronoun, he or she, randomly throughout this journal. However, when we talk about criminal defendants, we're always going to use the male pronoun because it's well known that the overwhelming majority of criminal defendants are male. And, but that being said, the fact is that the overwhelming majority, with exceptions, of harassers and of harassment tends to come from the male to the female or to the same gender and so on. And there are biological reasons, there are psychological reasons, there are societal reasons, but this is the reality that we face. And rather than saying that I would like to see a time in which harassment is equally perpetuated by both genders, I'd rather like to see a time where there isn't any. So with that in mind, understand that the use of the male pronoun throughout Judaic law is reflecting the reality that obtained then and obtains now, which is not negating. There are, by the way, matter of fact, the very first case of reverse sexual harassment by a female to a male is in the Bible. Anyone remember? Very first case recorded in any literature. Joseph, there you are. So we're not blind to the existence of there was a power differential. He was a slave, she was the mistress of the house, and so on. And again, it's very often not merely about an attempt to create a relationship where the relationship is not desired. There is a regrettable human tendency to misuse power and to derive satisfaction from exerting one's power to demean or to bend another person to your will. And this is a lot of it. It's not merely the fact that I'm attracted to someone and I'm going to get what I want, or under ordinary circumstances I wouldn't get the time of day. It goes far deeper. So let's take a look. So I'm going to begin, because of this, with a discussion about a relatively revolutionary idea in Judaic law. There is a word called ona'ah. It's overreaching here. The translation isn't good, but I just thought ona'ah comes from a Hebrew root called on, which means power. So in buying, the Talmud begins with a discussion of buying and selling. If I sell someone something, they don't know the market price. I mean, it's before, you could Google the price of everything, and even so people get cheated. But the point being, I sell, the proverbial little old lady a used car at a grossly overinflated price because said little old lady didn't know anything about the value of cars. Of course, this isn't the little old lady from Pasadena, but another little old lady. But be that as it may, those who are old enough will get the cultural reference. But be that as it may, the fact is that I know more about the value, so I sell you something for too much money. Or conversely, I walk into your house, see an antique bureau that's worth $100,000, and say, "Hey, that's a really nice piece of furniture. I'll give you $1,000 for it." This is overreaching. This is, oh no, you're taking advantage of your greater knowledge of the value of something in order to cheat the other person. You must tell them what it's worth. You're entitled to an appropriate broker's fee, an appropriate delta between wholesale and retail prices because of your cost of doing business. You're not entitled to buy something at a 99% discount because you know what it's worth and the other person doesn't. This is another whole topic for another time, but here's the point. The Talmud, and not just the Talmud, the Torah, it makes a fascinating leap because there's a verse in the Torah, Leviticus 25:14. Do I have it? Yes, verse 25:14. It says, "Don't wrong each other when you buy and sell," and then it says, 3 verses later, number 17, "Don't wrong each other, and you shall fear God." So the Talmud says the first is taking advantage of your relative power in monetary knowledge. The second is verbal wrongs. And verbal wrongs are not just verbal wrongs. Onat Devarim literally means the taking advantage of your power with regards to all matters that are not financial. So here are some examples the Talmud brings. So if a person is a penitent, someone committed a crime, paid their debt to society, repented, don't say to him, "Remember your former deeds." If he's the son of converts, don't taunt him, "Remember the deed of your ancestors." If you're a convert and come to study Torah, don't say, "Yesterday you ate unclean and forbidden. Yesterday you were eating frog's legs and octopi, and now you want to study the Torah given from the mouth of the Omnipotent." This is taking advantage of someone's vulnerability. This person is new to Judaism. This person is new to the community. A person has committed a crime and genuinely changed their ways, but their past is a vulnerability. There exists a fundamental prohibition in Judaism to gain power over someone, in other words, to lift yourself up by virtue of denigrating and pushing the other person down. There's a great story about Rabbi Shlomo Yaffe of Lubavitch, the 5th Lubavitcher Rebbe. When him and his brother was like 2 years older, were very little boys, so the Rebbe Rashab, Shlomo Yaffe, was very tall. Even, certainly for that time, even for today, it was like close to 6'3", I believe, 6'4". He was very tall. And as a child, he was very tall. His older brother was relatively short. So by the time one was 5 and the other was 7, little Shalom Dover was taller. So one day they're playing, and Reb Zalman Aaron, that's the older brother, is in charge of whatever game. But he doesn't like the idea that his brother is taller. So in the little white Russian town of Lubavitch, there was no lack of holes in the road. They had dirt roads, and they never, the Imperial Russian Road Service never came by. So the road was full of holes. They found a particularly big hole and made his brother Shalom stand in the hole so he should be shorter, so Shalom should be shorter and Zalman should be taller. So Reb Shmuel, the father, was also Lubavitcher Rebbe. He came out and went over to Zalman and said, if you want to be taller, find something to stand on. Don't put the other person in a hole. Don't put the other person down. But there is a huge human temptation to do this sort of thing, and because there's a tremendous, and the primary topic of today's discussion, because there is a tremendous vulnerability with regards to people's awareness of their ability to be harassed. The harassment, it's the realm, the realm of the vulnerability that exists in the realm of intergender relationships and so on is very great, and it's very easy to denigrate someone because basically, when we'll see this more later, when I invade someone's private space, which is in essence all of sexuality, is about sharing your private space with someone else. So when I invade unbidden your private space, this intimate area of your life, I am basically saying you are worthless. You don't even have the right to your own space. This and it's particularly egregious in this area. There are many other ways of doing this. There's background, there's previous history, there's physical appearance, there's disability, there's race, there's a whole range of things. But this particular issue is particularly egregious. So we go on to say, if someone is visited by suffering, don't go around telling him, oh, God is punishing you, because you don't know, but the person is vulnerable, and they'll start thinking this way. So, and then there's plain old, you talked about bullying. If donkey drivers, ass drivers, means to say people who, they buy grain in one place and sell it in the other, are looking for grain, don't say to them, oh, go to so-and-so sells grain. Don't send pizzas to people unbidden. Rabbi Yehuda says, one may not feign interest in a purchase, you have no money. Since known to the heart only, and everything known to the heart it's written, you shall fare like God. I know people who thought it was very amusing. They were bored souls to make appointments with real estate agents to see houses they had no intention of buying. And you're stealing the person's hope. You're taking advantage of the person's need to make a living. You're taking them away from other clients. But the main point is that you are taking advantage of the power differential. They need you, and you're taking advantage of that need. So there's a broad range of these things. The reason I bring this up is because before we get to the question of appropriate behavior in the realm of sexual harassment, we should understand that there is and more than that, the Talmud later says that you can pay back. If you overcharge or underpay for something, you can pay it back. But when you hurt someone's self-respect, you hurt their integrity, you hurt their sense of self, you damage their sense of dignity as a human being, it's sometimes impossible to ever restore that. And they carry that for the rest of their life. So even though there are less monetary sanctions, this is a profoundly disturbing thing, which has 3 points. One, that you yourself should understand how serious it is. And two, someone who behaves this way, there may not be specific criminal sanction, but this puts a person in the category of people who we should never allow any position of authority, of leadership in the community, of judgeships. There's a whole range of things that people who engage in this bad behavior, and for example, we're very careful in Jewish law about speaking ill of people, even if it's true. Where people behave this way, you need to tell, for example, prospective marriage partners that this person is a real miserable human being who does this sort of thing. So there are enormous social and in terms of positions, there are enormous disabilities inflicted on you. If you behave this way, you will never in the Jewish community be given any position of responsibility and authority. And indeed, according to Jewish law, a rabbinic judge, a rabbi, and community leaders, was a whole democratic system of community leadership in traditional Jewish society in Europe and the Arab lands. You could be removed from position for this type of behavior. And now I want to go very briefly, we'll have more time to talk about it, the Judaic approach to the particular question of harassment. So just the point, to the last point, if you publicly shame your neighbor, it's as if you shed his blood, because character assassination is a genuine form of assassination. Now, I want to go to vulnerability. Again, there are different social constructs and so on, but I think on the whole, there's a sense and borne out that the collective group of women, the exceptions individuals, respond differently to emotional vulnerability than men do. More importantly, the point is that certainly for much of history, and this is why there are all kinds of protections in Jewish law for women in marriage, men are physically stronger, and for most of history, until the Industrial Revolution, men controlled economic power much more than women, for the simple reason that if the housework and child rearing needs to be done at home by manual labor, that puts the men in the position to acquire money. And therefore women were always in a vulnerable position. So Rav says one should be heedful in the Talmud, one should be heedful of wronging his wife, for since her tears are frequent, she's frequently quickly hurt and quickly responded to. In other words, the idea being that one is subject to divine punishment and social opprobrium for hurting the feelings of someone who by definition is more vulnerable because of the status of a woman in a relationship where you have greater physical power and greater economic power. So the Talmud is very concerned about this issue, because the more vulnerable someone is, the more there's a power differential, the more egregious and the more we need to warn and proscribe bad behavior. Now, to move to there is a set of Jewish laws. And again, they're mostly couched in the male terms, but feel free to replace them with the female, because they're all about the idea that when it comes to the issue of sexual harassment, it all begins with a sense of entitlement, the sense that you have a right to interact in some sexual way with another human being. And the answer is that you do not, for two reasons. One, the only right, and again, though there are differences in Jewish law and what we call what Judaism sees as the universal human law, about details of laws of marriage and relationships and so on, but one thing is clear. The only right to a relationship that anyone has is one freely agreed by both parties without any pressure or any use of a power differential to get them. And the key and fundamental point to make over, a very, very important point, is that this begins within yourself. In other words, it's not us telling you what to do on penalty. A person needs to understand that whether you're under Jewish law or Noahide law, the only permitted relationship is a consensual one that matches the laws of whichever system you subscribe to. And therefore, the primary obligation is on the individual not to view another human being in an objectified way. We're not merely talking here about prudishness, which isn't really a Jewish idea. We're not talking merely here about one's spiritual status, though that's, as you will see, it comes out. We are saying that male or female, whoever you are, the premise that you look at another person as an object of attraction, as an object of the expression of your sexual drives and desires, is inappropriate and wrong unless there is a dignified agreement that such a relationship should take place. And again, there are differences in different legal systems in Judaic law and what it sees as the universal ethical law, which basically tends to leave it to each society to figure these things out. Any person who engages in any of the above-mentioned practices, which are going to be extended below, is considered likely to engage in forbidden relations and is suspect. But here is the key point. Arayot means someone you're not allowed to have a relationship with. Again, which is basically everyone except someone who you have an appropriate, mutually agreed upon relationship with. Frankly, in Jewish law, it tends to be exclusively within marriage. With regards to the larger society, the Torah has this premise of universal ethical law, but in this area, it pretty much leaves it to each society to figure out what it wants. It's forbidden to make motions with his hands or feet, or wink with his eyes, to share mirth with her and act frivolously. Remember, only joking. How many times in a sexual harassment case have you heard only joking? Well, this is what Maimonides is talking about. There are no jokes when it involves the objectification of another person. Never mind making remarks. Sometimes the remark, "Oh, you look pretty today," is actually a form of harassment. It's forbidden even to smell her perfume or gaze at her beauty. You have no business entering the space of seeing the person as an object of attraction unless there's a previous agreement. And in doing so, not only, and the issue is that from your own misbehavior, and it seems very draconian, but it works. It's forbidden to enter into privacy with any people forbidden, even if she's elderly or young. The only exception is a woman, her son, a father, and his daughter. Let me assure you that if in a work setting, you're never alone with a person who's subject to harassment, you solve a lot of problems. A lot of problems happen when there's two people in a room and there's no one else there. And Judaic law takes, again, a very drastic approach, but it works. And there have been some very large banks that have now, many corporations have instituted this premise, sometimes even the same gender because of our changing world. If you're never alone and you never look, sniff, if you never overtly look at a person, even as far as their perfume, if you're always in a position where you are not objectifying the other person, you are, because these laws are designed, the Talmud, people say, in the Talmud's time, women were locked up. It's not true. There are hundreds of financial cases, commercial cases, discussed in the Talmud that involve women of great financial, economic, and social influence. The goal of these laws is to ensure that I can relate to you in a business fashion, in a professional fashion, an intellectual fashion, in a communal fashion. There were many women with high communal leadership positions for the last 3,000 years in Jewish history. There needs to be boundaries and space. That's the lines. We talked about real, respect, education, the ability to be heard when you make a complaint. And last of all, L, lines in the sand, red lines. If you have an absolute red line that you're not going in any way, even within your own psyche, you're going to shut down any attempt to view someone who's working for you, doing business with, a client, anyone who you have a social relationship with, that I'm not going to view this person sexually. You are going to have healthy, appropriate relationships, and there will be no ambiguity. Because you're never going to touch them inappropriately, you're never going to talk to them inappropriately, you're not going to look at them. Staring can be very disconcerting, as people know. And you're not going to be alone with them. So these boundaries of respect are the key. The goal is not to tell people what to do. It's to educate them on the importance to acquire the sense of respect and dignity of a human being. Yes, it's very tempting to someone who appears attractive to you or appears vulnerable to you to step over this bound. But if you create these boundaries, you create the sense, I will not see this person except as another human being who I'm doing business, engaging in commercial activity, engaging in social or communal activity with, then you're not ever going to have a problem. If you never say anything appropriate, you never view the person as a target of objectification, and you're never alone with them, you're never going to have a problem. And you're going to be a better person who might actually be more interesting and attractive to someone when you do want to form an appropriate relationship. These are the fundamental keys of Judaic law. They seem very, very tough, very demanding, very extreme, but they work magnificently and don't for one moment prevent friendship, prevent professional relationships, they don't prevent client relationships. As a medical doctor, for example, there are no prohibitions. You do what you need to do. There are no issues with the gender of the doctor, etc., etc. But the same doctor who might, for example, might be an obstetrician, might be a gynecologist, with all that entails, nevertheless, the slightest inappropriate remark to a patient about, oh, your hair looks nice today, is completely out of line. Because There's everything professional, medical, legal, social, communal is entirely acceptable. Anything where you're crossing a boundary to objectification and use of the power, because even if the patient's paying, there's tremendous power a doctor has over a patient, a therapist, a lawyer. That is absolutely, and with these red lines, you can be any kind of lawyer, any kind of doctor, any kind of therapist you want, and never run into trouble. Last of all, I want to make a very important point about victim blaming. Because we often say, well, if usually it's a she, if she wouldn't talk that way, if she wouldn't be so loud, if she wouldn't dress that way, and so on. Now, let me put my cards on the table. In Jewish tradition, modesty, both for women and men, is a big deal. But modesty is a personal religious behavior. The onus for behaving properly and not thinking inappropriately, one of the things Jewish law brings to the table is that it all starts with your mindset. The onus is on the thinker and the doer, not on the person. So it says in the Talmud here that he that walks righteously and speaks uprightly, who is this? He shuts his eyes from looking upon evil. Rav Chir Ba'Abba says, this was one who does not gaze at women while they're standing over the laundry. As it was common for them to stand in the water and raise the hems of the garments. You did laundry by the river. And you did it by standing in the water, putting the garment on a rock and banging it. So you understand, you're standing in the water, you lift up your hand, you're banging it, your sleeves fly up, and, who knows what else. And you know what? The women are entitled to do laundry. We don't tell them, hang a curtain, do your laundry at night when no one's looking. The Talmud says we tell the guy to take the difficult, muddy, rocky path around the river so that you're not in a position to ogle them when they're doing the laundry. We don't say the responsibility is theirs. The responsibility is the viewers. We don't say it's her fault, it's his fault. Why was she dressed that way? That's a separate question that is between her and God. But it's our job not to look, not to be there, not to be in a position where we might even come to engage in the process of objectification. And that's my last point. And I think out of this we can acquire, a system for both education and for shifting the paradigm to criminal sanction and what punishments do I give and what do I threaten people with, to educating people to behave in a way that by upholding the other's dignity upholds their dignity. And I think it's a worthwhile angle for our society to look at, because as Sharon pointed out, whatever we've been doing has honestly not been working very well. You had a question?
A couple minutes ago you said something to the effect that it's inappropriate to even tell someone they look nice. I believe you said that in the context of doctor patient, am I correct?
Yes.
Okay, so I as a lawyer, a client comes in and I say, a female client, and I say, you look nice today. That would be inappropriate.
I would say, as unpopular as the sentiment is, I think if there's any sense that she's going to take it as a crossing of a line, in other words, of an interest in her as an object, I will have to humbly say that I think it's a problem.
Telling somebody that her appearance is even appropriate, even nice, even acceptable, that's out of line.
I don't know acceptable. I think lawyer-client, or I think in any situation, if it's a statement of acknowledgement of a person's physical attractiveness, there's a problem.
I believe you use the word look nice.
Right, so I am in best legal fashion, I am qualifying that, because to say, for example, that someone looks happy and upbeat and so on, but if you're referring to her physical appearance, I think that's a problem.
What about to a male client?
At the present moment, the statistics are such that the premise that there's something erotic in your saying is at 10% or less. So I don't, unless there's a specific concern, I think 10% is not something. Jewish law doesn't concern itself with such small percentages. there's a specific reason to think it might be foreseen as a form of harassment or intimacy, then yeah, that'd be a problem. And again, I think many people, including yourself, find this a bit extreme, but on the other hand, it works.
Thank you, Rabbi Yaffe. So I'm going to give a couple of to jumpstart some of the questions, and thank you, Jeffrey, for starting. That was actually one of my questions. I'd like to give Sharon an opportunity to respond regarding that question about, from a civil, a modern, secular perspective, is it appropriate? What's a red line of commenting on someone's appearance, practically and legal? I mean, not legally, but.
Yep. So as I mentioned before, in order for it to constitute sexual harassment, it has to be pervasive. And so if it's a sporadic, innocuous comment, like "you look nice," that likely would be insufficient. Coupled with a bunch of other things, it could be something, although I think it's a pretty innocuous comment. There's a difference between, I think, saying "you look nice" and saying "oh, you look good." I think there's a difference in how it's delivered. This is why these cases are so difficult, because they're so dependent on the facts. If I say, "Jerry, you look good today," that's very different than saying, "You look nice," or "I like your new haircut." So it really is dependent on the setting. It's dependent on how much is too much. I like to say sometimes that it's like a continuum. If you have an innocuous comment, it's never going to arise to sexual harassment. If you have a bunch of double entendres and you say them all the time, then that could pass the red line, as you refer to it, and potentially make somebody feel uncomfortable. So it's very fact dependent.
I would just like to qualify it that Judaic law isn't speaking about harassment claims, though if Judaic law was functioning today, it may have such a system. But it's not talking about harassment claims, it's talking about the type of attitude. Again, the Judaic law is focused on the internal life of the individual. And it's and to some extent, it's exactly the same. It really has to do with what you mean. It just appears to me, and this is the way I try to live, that when in doubt, it's always easier not to say something than to unsay it.
And let's go back to what I answered. It might be easier in civil law if there were the kind of boundaries that there are in Judaic law.
So let's talk about that. Understanding, the Jewish law has a very long, drastic, safeguards, boundaries. Rabbi Yaffe referred to one of the most famous ones, yichud, which is prohibition against any seclusion with a member of the opposite gender other than immediate family relations. Is there anything like that because of what's going on today, and we're knowing that a certain change has to happen, not just, they make the Borscht Belt joke, the guy goes to the doctor and says, "Doctor, it hurts when I go like this." So the doctor says, "So don't go like that." So, other than, in today's day and age, it's saying there's a lot of problems, a lot of harassment. Many times responses to the accused is, "You shouldn't have done that, you shouldn't do that." Can we back up, think of similar things that would be acceptable in a more liberal, open society, to enact certain measures like that, of like in a workplace? Rabbi Yaffe mentioned in banks, certain banks are making it required to not be alone with a member of the opposite gender, a client or a coworker.
So I want to ask a question. Under Judaic law, we come to this program, and let's say you're not here, but let's say it's just Rabbi Yaffe and me, and nobody else shows up. What happens?
So that's a very good question. The idea in Judaic law, Rabbi Yaffe can add some of the details, is that you can't ever be alone. There's a qualifier, has to be in a room, a locked room, or a room that's, extremely very secluded. It's like a country road. If, for example, a person could take a car ride with a member of the opposite gender if it's in a decent, populated road, a public place. But if you're going to take a 5-hour car ride in a lone country road in the middle of the night, that'd be the same as being in a locked room, which is the prototype, the famous case of prohibition of seclusion.
But for example, if you're sufficiently senior that no one will walk into your office without your permission, that's a similar issue. But any place that is public access, and more than that, for example, if someone comes to meet you in your home, but your significant other is in town and could pop in at any moment, again, then there's no issue, because the law deals with common sense. As Rabbi Manis Friedman, who talks about these things a great deal, makes the point that there's something that being alone, knowing that you are completely free of being disturbed because the door is locked, or you're a very senior officer in the bank or something, there is a certain intimacy and pressure created there's a certain suggestiveness created just by that situation.
So, can I go back to one more question before? I will ultimately answer your question, but this isn't even so much a question as a comment, that in preparing for this program and going through some of the scenarios and going through some of the boundaries, I know that there's a prohibition against shaking my hand.
So, Rabbi Yaffe, you have to qualify that.
Yeah, in other words, there's no it's like this. Strong physical contact between the genders is not permitted by Jewish law. Technically, if it's not affectionate and merely social, it isn't prohibited. But the same way some people are a little bit more careful about kosher, they have some extra standard of kosher, some people are more careful in this area. And in our community, we tend to be more careful about this, among them because of the fact that especially in our community, in the greater Chabad community, we're always involved with people, we're always counseling people, we're always sharing, very deep and personal things with people. So we think and my wife takes the same approach, a little bit extra boundary than is strictly demanded by the law. But it wouldn't be correct for me to say that there exists an absolute prohibition in Jewish law against shaking someone's hand in a social way. However, I will tell you that we had a good friend who was actually one of the first senior women in the early 70s in one of the big New York brokerages. And she also became quite religious at the time. She's been a very secular person, I don't think she was even a 3-day-a-year Jew, And she got very involved in Judaism, became very religious. And one of the things that she told us, sitting around, I remember my aunt's Shabbat table, that she stopped shaking hands, and everyone's, giving her a hard time. This is the 70s. And she says, especially on Wall Street, and she, just for the record, I was a child at the time, but one of the things I remember my mother remarked is a particularly attractive woman, by the general, by the general standards of mid-70s America, and she says that especially on Wall Street, which was a very, had a very, locker room kind of vibe for a very long time, maybe to this day, is always the guy who shakes your hand and hangs on just a little bit too long, and it's really creepy and really uncomfortable. She says, now I don't shake hands, I don't have this problem. So, no, so what I'm saying is, even things that seem very extreme, there's actually a degree of reason to them. But at any rate, it would be unfair to describe this as, shall we say, the letter of the law, but it's certainly within the spirit of the law, especially if you want to make a point of being very careful about these things.
But your description of the difference between professional and anything that isn't professional puts it into perspective. So it's hard for me, for example, in beginning our discussions, it was hard for me to understand that with respect to shaking my hand, if there's somebody who may not feel comfortable shaking my hand, but does feel comfortable and is permitted to be my gynecologist.
And you know what? I know many highly orthodox male gynecologists who exactly, because this is about profession and this is about the safeguards, and someone who is any kind of doctor and therefore is in this power position has to be extra careful, not less careful. So that's exactly. Yeah, it sounds strange until you analyze it logically.
It does.
So back to the question. In today's day, Sharon, it'd be very interesting to hear your suggestions for the greater society. Your presentation was amazing. Is there anything
I don't
that's
think
appropriate?
You can have a situation, nor do I think that a bank can have a situation saying that two people can't be alone in a room. And there's a difference between being alone in the stock room and being alone in an office. And to me, that in this day of trying to have equality for as many people as possible, that creates a false tone. So I don't think it's possible. I don't think it would help the situation. And I think it's a much more psychological, esoteric issue, which is, as you put it, in terms of respecting the dignity of everybody. If you respect the dignity of everybody, there doesn't have to be a prohibition about anybody being together. By the same token, some employers have policies saying that you can't supervise anybody that you're having a relationship with, and then you go farther. You certainly can't supervise your spouse, or a nepotism policy. But you go farther. If somebody's your friend, should you be supervising somebody who's your friend? These are the very, very difficult issues. But in the context of what you're describing, it potentially puts you in a more difficult situation in terms of obeying or sticking to the boundaries in dealing with things in a professional manner.
I'm just asking, so you're saying it wouldn't be appropriate to make a rule, because I know there are some, certainly in Europe, there are some financial harassment rules that two people of any gender, because we don't make distinctions, shouldn't be alone in a locked room, because there's no reason for the room to be locked.
Well, maybe it's a bank vault.
Okay,
and
the bank vaults tend to have cameras these days.
But so now you've got an exception then.
There's not just an exception. A room with a I'm just saying, just for the record, a room with a camera that has that there are more people viewing the security feeds is the same as an open room. Just for the record.
Okay, but I still think I don't think, number one, I don't think that it's a viable, workable rule, okay. And number two, I don't think that. I don't think it's addressing the issue. It's actually what I think about the laws, the new New York State and New York City laws. I think that when you impose an obligation to do training and then you check off that somebody's done the training, you don't really reach the real issues. The real issues are much deeper than that. I mean, maybe it's a step in the right direction to require that people have policy, that employers have policies, which basically has been the status for a while, not a statute requiring it, but any employer in the know would have a policy. But I think sometimes when you say do training, and you check off the fact that you've done the training, it permits people to not get into the deeper issues about what it means to respect or dignify people. Can I ask one more question?
Sure, and then someone's waiting for
Okay, so I have one more question under Judaic law, and that is whether there are any rules with respect to bystander intervention. So as the EEOC has suggested, it's on us, it's on all of us. And so if we're a bystander, we should not stand there and watch somebody else engage in discrimination, and let's teach people about what they can do to affect it. Is there any similar responsibility under Judaic law.
So you have given me a few new slides for the next program. Thank you for asking that. Jewish law has two very important rules. One is don't stand idly by the blood of your fellow, which also means this because it's akin to murder, the social assassination of your fellow. Secondly, Jewish law says that you have to admonish people. There's an obligation to correct bad behavior where it's appropriate. In other words, you wouldn't go over to someone, who has, very little knowledge or commitment to Judaism and say, why are you eating a cheeseburger? Okay, isn't kosher. But it would be appropriate. Everyone knows they're not supposed to harass. So there's an obligation to correct others, and even under the universal ethical code of what we call the Noahide laws, the code that Judaism sees as applying to all of humanity. Hugo Grotius writes a lot about it, actually. There's the obligation to have just courts of justice also means individuals are obliged to create a just society. So there's an absolute human obligation to intervene, to interfere. As a matter of fact, if you want to go to an extreme, we're not talking here about harassment anymore, but Jewish law says that if you see someone attempting to sexually assault someone, you can stop them with all the steps you would take to stop a murder, up to and including killing them, because a sexual assault is as egregious as murder. It says this right in the Bible. For as a man arises against him to kill him, so is this matter, referring to someone pursuing a young woman in this case. By the way, too. But the larger point is that there's an absolute obligation. And here I want to say it's not about education. It's not about the workplace. This has to begin in junior high, in elementary school. In other words, so much, on one hand, we're in the world of equal rights. On the other hand, the level of objectification in the mass culture, in film, in video games, etc., and even of the way people behave, even the way people's parents behave, is quite remarkably bad. No other, sorry for the non-specific legal term, but it's real. And you're not going to get, and this is, by the way, why Jewish law demands that everyone study the Talmud. Everyone study Jewish law. Until you educate people in the schools to respect the dignity and boundaries of others. Let me tell you a story. I have a friend, Rabbi Samuels.
Oh, wait, I'm sorry. Yeah. Rabbi Yitzi wants his boundaries as moderator to be able to comment.
Thank you for not being a bystander. Rabbi Yaffe's a very senior, famous Chabad rabbi. I'm a little intimidated to, Anyways, we want to take a few questions, and then we're going to save the last 10 minutes to go back to our presenters to maybe address a couple of main scenarios. In the back, ma'am.
One of my questions with the policy about not being alone with something is you're trying to avoid a situation where someone could accuse you of something. You also have the problem as an attorney that you have to keep confidence, and that third party may not share that confidence, and they could be called as witnesses against your client, especially in criminal terms. So how do you enable that without orchestrating a meeting that could be potentially dangerous to your client?
So let me just repeat the question because I was told. So the question is that even if you wanted to have this sort of anti-seclusion policy, you have privacy requirements, and that would seem to those would be violated if you made everything more public.
As a rabbi, I have privacy requirements, and as a rabbi, I meet with people about highly personal things that they don't want anyone else to ever know. The simple point is I can sit with them. I can sit with them in the library of my synagogue that has a glass door, but it's a glass panel, but it's soundproof. As a matter of fact, Rabbinic Council of America just issued a long set of ethical guidelines, and one of them is that rabbis' offices should have glass panels. And and a camera works too. The point is, I can have verbal seclusion. I can have complete non-hearing and complete privacy without actually violating this law. The room doesn't have to be locked, and there can be a glass panel, or I can sit in the conference room, which is what I often do in my synagogue. I sit in the conference room. Everyone walks by, can see that I'm sitting there with someone. They can't hear what I'm saying. Again, the ability to speak to someone privately this again means to say that I'm not going to be alone in a room with the door locked, that someone has to get me to open the door where there's no visual of what I'm doing in that room with the other person. That's a very narrow law. All the, rabbis and wise women in the Jewish community have counseled individuals on extremely explosive and private things for thousands of years. It's never been an issue.
Quick aside, I know of a case where there was a glass door and significant accusations of sexual harassment. So
I'm not saying it prevents it. It's all about the education of the individual. It isn't about the other in the situation. It's about who you are. And again, when we finish with the questions, I'll tell that story.
Yes.
Follow up. I'm sorry to preempt this, but I want to take it to another level because I have clients who don't want anybody to know they're my clients, and I don't want anybody to know they're my clients. And I couldn't possibly meet them in a public space, or even, sometimes they do come to my office and they walk in and out of my building. But
you make them take the tunnel to get there, though, right?
I meet people in hotel rooms sometimes because I don't want anybody to know that, or they don't want anybody to know that. So how do you handle that?
So if I was there are many attorneys who follow these laws. So among other things, you could meet someone in their home, assuming that there's, say, a kid at home has no idea what you're talking about. You want to meet someone in a hotel room. No, let me be very honest. You want to meet someone in a hotel room without anyone knowing. Set up a camera with your secretary. You know what I mean? Your secretary knows who you're meeting, right? There are ways around this. Meet these days, the Afghan terrorists, they meet on mountaintops because they don't use electronics and they don't want to be picked up by a mic. So they meet right on the side of a mountain where the sound gets reflected. Everyone sees them talking, knows what they're talking about, don't get to see who they are. What I'm saying is there's always ways. Even the simple thing of asking, of telling the maid service in the hotel that they can knock and come in. They'll have no idea what you're talking about. They're not going to identify your client, but as long as the sign on the door says, come in, without demanding that they knock and ask, that's sufficient. There are ways around it. Again, the key thing is your maintenance of a sense of, shall we say, a degree of knowledge that if you try anything, you're likely to be compromised.
Mr. Evans?
Thank you. I have a question to the panel, probably more specifically to Sharon.
You're going to make it tough, too, aren't you, Richard?
Yeah, it's going to be tough. Back in the day when we all did that horrendous matrimonial work, and back in the day. And today we're all litigators who do civil litigation. How often were we, and are we called into chambers by a judge who's trying to settle a case? And I think about our colleagues, women attorneys, who I have had knowledge of having been brought into chambers in matrimonial cases, and the judge using his influence not only to inquire on matters that have nothing to do with the case, but more particularly to use that leverage and place the female attorney in a very precarious position of you play along with the judge because you have a client to represent, or you are truly intimidated and harassed, and yet you have no recourse given the circumstances. So how does Jewish law approach that? And Sharon, how do you these days approach it?
So I'm just going to answer very quickly and say welcome to the real world. One of the things that I've given in your packages is a policy and procedure from the court system. And so, it's all gradation, though. So the court system has a policy against sexual harassment. There are ways to report it, but you can always understand that reporting sexual harassment or any form of discrimination never really makes you whole. it doesn't eradicate it. The only way to eradicate it is, as the rabbi says, start in grade school, start educating children, things of this sort. You mentioned matrimonials, and I'm going to steal the moderator's question also, because there are also prohibitions in our rules of professional conduct against various kinds of sexual contact. And there's a different prohibition for domestic relations matters, probably because of the vulnerability of clients in domestic relations matters. So Rule 1.8 of the Rules of Professional Conduct provide that a lawyer shall not, as a condition of entering into or continuing any professional representation by the lawyer or the lawyer's firm, require or demand sexual relations with any person. So there's the power aspect of it. Secondly, employ coercion, intimidation, or undue influence in entering into sexual relations incident to any professional representation by the lawyer or the lawyer's firm. Again, the power aspect of it. But the third one is, in domestic relations matters, enter into sexual relations with a client during the course of the lawyer's representation of the client. So there's a growing recognition in both the court system and in our own professional rules about these issues and trying to maintain professional boundaries. But
do you know of any case locally in which a female attorney has actually filed a complaint against the judge for alleged harassment inside chambers?
I believe that it has occurred, and it also depends on the level of it. I can tell you, for example, of being in conferences with a judge and opposing counsel, and opposing counsel coaching the football team, and they spend the whole conference talking about football, and there's nothing that in fact, in one, I said to the judge before we left the conference, tell me, Judge, what team I should study up on for our next conference so I can participate. That didn't go over really well. But there's many ways of excluding people. And, you know, if they don't get reported, it's not going to change. So it is important to report it. I believe that there have been reports, but it's also very confidential and very difficult. I think that it is my belief that there are certain judges who didn't receive positions, promotions because of things. But
by the way, actually, it's interesting. Jewish law actually relates to this on several levels. Number one, it is forbidden for a judge, well, there's rules of conduct, it's forbidden for a judge to show any favoritism or extra friendliness in the context of a court case. In this case, we're talking about the plaintiffs, because Jewish law, there's no lawyers, a panel of judges. But you're not allowed to show to anyone who's party to a legal case favoritism. So if you start talking about your kid's football team or Little League or you happen to be a Buffalo Bills fan or something, although that demonstrating even innocuous friendship to one and not the other is a prohibition. Number two, Jewish courts are always panels. There's the only judge who judges alone is God, it says in the Ethics of Our Fathers, that the rabbi quoted. So you tend to be if you're in conference, it's going to be with several people. Even because nowadays they do have something called a toeing, sort of like a representative, a de facto attorney in Jewish law. And last of all, lo seguru pnei ish, fear no person. This is said in the context of law. You have to be willing to call anyone out, no matter how they are. But here's the thing: you talked about people not getting promotions and so on. In Jewish law, there's something called renana de lo pasuk, which means to say a rumor that doesn't cease. If there's enough complaints made by enough women or men or whoever, that person will be considered morally unfit to be a judge and be disbarred. If there are persistent rumors of bad behavior of this sort, Jewish law demands the disbarment of this judge, even if nothing can be proved in an open court. Jewish law halacha demands very high ethical levels of its judges, and though appointments tend to be for life, they're on life subject to good behavior. Good behavior is defined very narrowly. I am not naive enough to advocate for the imposition or even the adoption of this system, but there are many important ideas in the Talmudic system which I think could be very helpful. And apropos of education, it's better longer, but my colleague Rabbi Samuel's Chabad of Simsbury he had this large group of people he studied Talmud with, all men, and they used to harass him, not in our sense, that, you send your boys to a single-gender school, how are they ever going to learn to properly interact with women when they get married? First of all, look, I have a pretty happy marriage. He says, secondly, let me tell you something. If the premise is that by sending your child to a standard mixed-gender public high school, no offense, I'm sure most of you went to such a school, is a good indicator of successful relationships later in life, let me promise you that if today you went and treated any woman the way you treated girls in 11th grade in high school, you're going straight to jail. And this is my point about education.
Just, I have to repeat the second code for the video is 2479. We have a few minutes left. Any other questions from the audience regarding the topic? Any specific lawyer-client issues? Or I can give a scenario. Would you like to do a scenario, Sharon?
If we end at 2, that's what my watch says.
Right, we have a couple minutes. We have a couple minutes.
3 minutes.
3 minutes.
3 minutes. Oh, my watch must be fast.
Okay, I'm going to read. We spoke about a lot of these scenarios from Sharon's one of her handouts. It's in the handout, I believe. But just to sort of bring it together.
If we do the first one, it's kind of interesting.
Okay.
It's not my case. So I had prepared a bunch of scenarios from cases I've handled. This is not my case, but you're going to recognize it from much publicity in the newspaper. But I think it points out some issues. So a new professor begins work at a local college. He has a reputation as a womanizer. He engages in a sexual relationship with graduate students and at least one prospective graduate student. The graduate and prospective graduate students do not complain, but others do who suspect favoritism. So let's assume that you are the lawyer for that university. What do you do? Is there anything that's happened that's illegal? Is there anything that's happened that impacts Judaic law? So let's see what they have to say first. You recognize the scenario, right? Okay. So what do you think? And I haven't given you a lot of facts. I made it a very brief statement, but yes.
He's both a lawyer and the director of a number of companies. Something like this comes up. Problem is that if you permit that as the employer, higher up, to continue, it incites or allows or says, well, this is the tone of our company, and now you have a runaway, where you start getting your company involved in illegal activity. Although what seems to be consensual on the part, let's assume that the young lady initiated for her benefit the relationship with the professor.
Does that make it consensual? Or is the fact that she didn't complain indicative that it's consensual?
She's looking for something and enticing him.
Does that make a difference? Now, it may make a difference under civil law. Does that make a difference under Judaic law?
Well, under Judaic law, all adults are responsible for their behavior. However, there is a rule that anyone, I thought the line, a reputation as a womanizer, the rule is that anyone who has a weakness in a given area, we disallow them employment in an area where they're likely to get into trouble. So in the Judaic law, no university should hire such a person except to teach men, if there's such a situation. But you wouldn't give him access to women because the fact is there's a power differential here, and he can engage in this behavior or solicit it. Even if she's the one, it takes two to tango. If she's soliciting, he has to be solicitable, and that's the problem. So I would say Judaic law would make sure such a person never teaches women.
No.
Or if it's a woman professing with men.
We would have a way of using hospitality to gain an advantage. A woman who's a salesperson.
So wait, let's just stop on that for a second. So the statement was that women have a way of using sexuality to gain an advantage. Anybody want to respond to that?
You've got all advertising on television.
Well, but that's not necessarily women. That is society objectifying women.
But this is exactly the point that we began with Jewish law. Don't look. If someone, even if someone is trying to sell you something and, and so on, don't look. Don't respond. In other words, there's no, she isn't forcing you. She isn't tying you up. You're responding, and you have an obligation not to respond.
As the boss, you got to tell them, hey, you didn't make money.
Exactly.
All right.
So deep issues in all of this. Very, very complicated issues.
All right, we're out of time. We could be here the whole day. Thank you very much to our presenters for really doing an amazing condensing of so much knowledge that is so practically useful in today's day and age. And like I mentioned just one more time, if you would like to fill out this the back of that page that I gave out, and you want to put in that little